Hello everyone, welcome to the fifth video of GDPR explanation. Today we are going to understand the territorial scope of GDPR. This is very important in the sense that territorial scope is the most important aspect of any act, which lets us understand whether the law applies to us or not. My name is Shalini Garg and Shreya and I are going to cover detailed explanation of Article 3 of GDPR along with the relevant examples for you. For your reference, we have already covered the introduction part, Article 1 and Article 2 of GDPR. If you haven't watched it and wants to understand these articles in detail, I will provide you the links to the articles below. And I highly suggest you to take out just 10 minutes to have a quick and easy understanding of the topics. In this video, we are talking about the territorial scope of GDPR. I assure you, all the privacy professionals faces one common question while dealing with data of any organization. That is, which privacy regulation is applicable to the organization in dealing with customers' data? To answer this question, privacy professionals should ensure if the organization falls under the territorial scope of any privacy regulation or not. So let's understand through this video which organizations come under the ambit of GDPR, which is also the most stringent regulation in the privacy. Article 3 explains territorial scope of GDPR and it has 3 clauses. Let's cover each clause in detailed sequence. Clause number 1. Clause 1 incorporates that the regulation shall be applied to any establishment which is established in the European Union. It could be a controller or a processor. Both comes under this ambit. Therefore, establishment should be in the European Union, but it is not required under this clause to have the processing activities too to be done in the European Union. So processing activities can be done somewhere else too. But when we talk about processing activities, it should be done in the context of the activities of the establishment in the European Union only. One important point to note down here is that the establishment does not have to be a physical office or a registered legal entity. Establishment is a flexible term in the regulation and can be used in a broader sense. Now let's understand this with the case of Veltimo, which is a leading case in GDPR. Veltimo was a registered Slovakian company. It dealt with property matters in Hungary and provided free 1-month advertising services to the advertisers. The company in fact had a representative in Hungary and its website was also written in Hungarian language. So what has Veltimo done with the personal data of the advertisers and what was the ruling? Veltimo collected personal data of the property advisors. And when these property advisors requested to delete their advertisements as well as their personal data, the company did not delete the data, and as a result, several complaints were lodged by the advertisers before Hungarian Data Protection Authority. Veltimo had been fined by the Hungarian Data Protection Authority for breaches of local law. And when Veltimo went on to challenge the fine in the Hungarian courts, the court referred this case to the Court of Justice of European Union, which is also called as CJEU, asking whether Hungarian law was properly applied in this case or not. The CJEU found that the concept of establishment must be interpreted broadly. The legal form of such establishment, example branch or subsidiary etc., is not the determining factors. There is a 3-pronged test. Number 1, is there an exercise of real and effective activity, even a minimal one? Number 2, is the activity through stable arrangements? And number 3, is the personal data processed in the context of this activity? For answering this question, CJEU considered that Veltimo have a relevant establishment in Hungary because its data processing was done in Hungary and considered as real and effective activity under the GDPR framework. Therefore, even a single representative present in the European Union can be considered as an establishment in the European Union. For example, any organization which has European Union sales offices is considered as an establishment. It need not necessarily be the branch or a subsidiary with a legal personality. It can even be a person who gets involved in a real and effective activity. Now, Google Spain case is also one of the leading case law to understand the territorial scope. And if you want the summary of Google Spain case, kindly comment case law in the comment section below and we will be providing you with the quick summary. Now let's understand this clause with an example too. For example, a car manufacturing company with headquarters in the US has its entire operation activities including marketing and advertisement done at Brussels branch. Hence, Brussels branch can be considered to be the stable arrangement which exercises real and effective activities. So this was the detailed explanation of clause 1. If you guys have any doubt, let's discuss in the comment section. Now let's move on to clause 2. Clause 2 covers the situation where a controller and processor is not present in the European Union and they process the personal data of the data subjects who are in the Union. The major reason for adding above mentioned clause is that the regulation was to ensure that natural person gets all the protection that they are entitled to under this regulation. So when we discuss about the data subjects who are in the European Union, it will cover data subjects who reside in the Europe, as well as includes the people who are passing through Europe or have a temporary stay there. So clause 2 also describes how an organization which is not established in the European Union are subject to GDPR. Well, they are subjected to EU GDPR when they process personal data about the EU data subjects via performing two kinds of activities. Number 1, the offering of goods and services to data subjects in the European Union, and number 2, by monitoring the behavior of data subjects in the European Union. So now the question is, what does offering of goods and services to data subjects mean? So basic understanding of the offering of goods and services is that there must be a visible intent of the organization that the offering is directed to the EU data subjects. For example, if the organization has provided an international contact number for them to reach for the goods or services, or by using an EU currency or language, it shows organization is intended to offer the goods and services to the EU data subjects. Please note that the payment against those goods and services is not the relevant factor here. Now let's see under which situation offered goods or services are not considered as offering. Mere accessibility of the controller's, processor's or an intermediary's website in the Union will not be considered as offering of goods or services. Or accessibility of email address and other contact details will also not be considered as offerings. Whereas there are some situations where offering of goods and services are considered as offerings. For example, if the organization is using a language or a currency generally used in one or more of the member states with the intention of offering goods and services in that other language, or if the organization is mentioning customers or users who are in the European Union. Now let's understand this clause with the help of example as well. For example, a hotel and a resort chain in South Africa offers package deals through its website, which is available in English, German, French and Spanish languages. But the company does not have any office, representation or any stable arrangement in the European Union. In this case, in the absence of any representation or stable arrangement of the hotel and resort chain within the territory of the Union, it appears that no entity linked to this data controller in South Africa can qualify as an establishment in the European Union within the meaning of GDPR. Now, let's understand what does monitoring the behavior of European Union's data subject mean. To summarize it in short, monitoring means collection of personal data for the purpose of subsequently using it, like profiling. A few examples are electronic gadgets such as iWatch, health apps, CCTV camera, etc., which collects the information of people and evaluate their behavior and day-to-day activities. Merely collecting data without any subsequent behavioral analysis is not considered as monitoring. There is a list of criteria which is available as to what may be considered as monitoring and what not. So the first is ascertain whether the natural persons are tracked on the internet or not. If yes, Do they have a potential subsequent use of data processing techniques? If yes, whether the techniques must consist of profiling a natural person? And profiling must be done in order to take decisions concerning him or her. And last is, profiling can also be done for identifying natural persons' personal preferences, behaviors, or attitude. Now we can understand this clause with the help of another example as well. For example, a US citizen is traveling through Europe during his holidays. While in Europe, he downloads and uses a news app that is offered by a US company. The app is exclusively directed as the US market, evident by the app terms of use and the indication of US dollar as to the sole currency available for payment. So the collection of US tourist personal data via the app by the US company will not be subject to GDPR. We have talked about offering of goods and services in the EU and also monitoring the behavior of the data subjects in the EU. And I seriously hope you got the clarity on clause 2. And if you have any confusion regarding clause 2, you can definitely ask us in the comment section below. Let's come to the last clause, clause 3. So clause 3 describes the situation where the controller is not established in the European Union, but established in a place where the member state law applies by virtue of public international law. Here, GDPR will be applicable. Situations may include member states' diplomatic mission or consular post. It simply means there is a consideration that GDPR applies to the personal data processing carried out by EU member states' embassies and consulates located outside the European Union. When we say GDPR is applicable, it means all the relevant provisions of GDPR are also applicable, such as data subject rights, obligations of controller and processor, transfer of personal data to the third countries or international organizations. Let's understand clause 3 with the help of an example. A German cruise ship traveling in international waters is processing data of the guest on board for the purpose of tailoring the in-cruise entertainment offer. While the ship is located outside the Union, in international waters, the fact that it is German registered cruise ship means that by virtue of public international law, the GDPR shall be applicable to its processing of personal data as per Article 3, Clause 3. So this was Article 3 of GDPR. We have tried to cover a lot of points in the video. We might miss out a few points, and therefore, for your reference, we are providing a few links which you might want to go through to have a deeper understanding of this article. In our next video, we are covering Article 4, that is definitions part. To watch more such videos, and if you need a simplified version of GDPR and data privacy regulation, kindly reach out to us. We will be more than happy to simplify it for you. If you have any queries or concerns, or if you want to learn any related topic, kindly comment on the comment box below. We will be happy to cover that for you. If you like this video, please subscribe to our YouTube channel and follow our LinkedIn page, Ministry of Security. Thank you.